seated. Good afternoon. We have the parties. I know who you all are. I've talked to you. I don't know if I've seen you. Starting on the left, please identify yourselves for the record.
Very cool. I represent the Lincoln.
Jay Clark for the plaintiff.
Catherine votes on behalf of Randstad and Dr. Smith.
Thank you very much. Okay, we are here in the case of Kelly Swalling, plaintiff versus Urgent Medical Center et al. Case number 16-2-02541-6 on plaintiff's second motion to compel discovery from Randstad defendants, and I've received the motion, supporting materials, as well as a response and supporting materials, 371 pages there. I don't have hard copy, but I was reviewing it on computer, and I also have a reply with a much smaller declaration from plaintiffs. I've read all that, and I'm not going to steer the party's argument too much, other than to say that there's apparently an issue as to whether you believe the agency theory is viable or not seems to determine where things go. I know I said I wouldn't steer it too much. Maybe I just did. In any event, feel free to discuss what you think is appropriate. I'll turn it over. Give me 1 second. Moving party's going to go first, but I do need to log in. I just changed my password. Give me a second. We're a go. So, take it away.
Yes, Your Honour, we will ask before the court on August 10th in relation to motions to compel. And the motion today really arises out of documents that were produced following the court's order on August 10th. As a preliminary issue, I would like to remind the court of the very broad scope of the Discovery Rule CR 26, and that the discovery of information is permissible if there is a reasonable calculation it's going to lead to the discovery of admissible evidence. It's not a ground for objecting that it won't be admissible at trial. This is a very substantial medical malpractice case. Kelly Swalling is very significantly disabled. She's a young woman. She's had a stroke. She's lost her house. She's lost her job. She's lost custody of her children. She's going to be disabled for the rest of her life. So the potential value of this case is very significant. One of the defendants in the case is, as Your Honour is aware, is Randstad, and Randstad were the agency who placed Dr. Smith with the urgent medical clinic, and pursuant to the last, let me backtrack a little bit. There are primarily two significant claims that we are pursuing against Randstad. One is there's a potential negligent credentialing claim relating to what they knew, should have known about Dr. Smith and her credentialing. And the second issue is that relating to agency, and it's the plaintiff's position that Dr. Smith was the agent of Randstad. As Your Honour is aware, there are a number of criteria that have to be addressed and considered by the jury when considering whether an individual is the agent of a particular entity. And one of those issues is the degree of control that's exercised by the principal over the alleged agent. And so they are the issues that we are addressing and looking into with the Randstad defendants. Now, following prior to the last hearing, the last motion to compel, which was August 10th, we had very limited discovery of information against Randstad. I think essentially, a couple of pages of documents. After the court ordered disclosure of information on August 10th, we received 94 pages, and that was just a summary of emails, messages, telephone notes that pertain to Dr. Smith, that pertain to Dr. Smith's relationship with urgent medical, that pertain to communications that pertain to Kelly Swalling's care. And so what my office then did is we have gone through that document, and we have not asked for every single communication within that. We have identified those that we consider may contain relevant information. The defence position has been, well, this is a verbatim summary of all these communications. You do not need the actual communications, and that quite simply is not true. We've set out in our materials, and specifically in our motion on pages 9 and 10, just some examples, and we didn't include all of them, but just some examples of summaries that are contained in that 94-page document that there is information, there's information missing. And there's information that's contained in there that clearly could be potentially relevant to claims of agency and negligent credentialing. For example, December 30th of 2013, 3 days after Dr. Smith saw Kelly Swalling, there's a note suggesting that Randstad is searching for Dr. Smith's updated medical license and continuing education. There are, in January 2013, there are some notes about a potential incident and a patient complaint. In August 2014, there's a suggestion that Randstad was asking for Dr. Smith for documents that could be backdated. And so we don't have these actual communications. All we have is a summary, and oftentimes a summary appears to relate to a chain of emails that's gone back and forth, and we basically don't have that. So what we are seeking, Your Honour, in relation to that summary document, that 94-page summary document, is we have identified those specific emails or email chains or documents where we would like the actual document itself rather than just the summary, which does not contain the complete information. And in the proposed order that we submitted to the court, we listed out specifically everything we were asking for. So to address one of the, I think, the concerns that was raised by the defence, that we were on a fishing expedition, that this was overly broad, that they would have to go looking for more information. We've really made a good faith effort here to narrow down those documents and emails which we based on the summary, appear to contain information that may be relevant either to a negligent credentialing claim or to an agency claim. The other issue I'd like to bring to the court's attention is that Defence Counsel represented that this summary document contained all potentially.
I didn't know that the other party was going to be present, but that's fine.
Okay.
We'll call her up.
What's the, do you want to call her?
Was anyone we can, we will, since she's holding on call. Compel, I believe she's for Urgent Medical Clinic Center.
Right.
I didn't anticipate her being here, though I may have mentioned at prior hearings that I'm okay with parties appearing telephonically from out of the area.
What's the,
Does a motion, she can listen in. It doesn't concern her, but she's a defendant. You have a phone number? Anyone?
yes, can I get Beth's extension and I'll patch it
Yeah.
through?
It doesn't say what it is on this phone right here. There's
Are you there?
Yes, I am.
Okay, one moment, please.
Okay, can you hear me, counsel?
Yes, good afternoon, Your Honor. Rihanna Frownafel for Urgent Medical Center. I apologize. I was waiting for a call from the court.
No, that may be my fault. Are you on speakerphone right now?
I am not. I have my headset
Okay.
up my ear.
Here, let me try this. Are you fussing with this back there? Okay.
I already have the button.
Oh, okay. This is not, we don't typically work together. My Jay is on vacation.
Okay. Can you see if she can hear you okay?
Does that sometimes. Can you hear me now?
I can, yes.
Okay, I think the issue is I can't hear her very well.
Trying to.
How about now? Can you say something? Say hello or testing or something like that. Ms. Fronefeld.
Yes, you're kind of coming in and out, Your Honor.
Okay.
If it helps, I don't anticipate participating in the hearing as I am not party to the motion. So it's
Noted.
more important for me to be able to listen than to speak.
I appreciate that, and I agree. They're party in interest at this point with this. This motion is not directed to the Urgent Medical Center defendants, but they're certainly, I imagine, interested in its outcome as it relates to issues in the case. So she's here with us, and Rihanna Fronefeld, is that right? Did I say that right?
Yes, that's correct, Your Honor.
Okay, and I remember you. I can picture your face, but she's here on behalf
Yes,
of Urgent.
thank you for allowing me to appear by phone.
You're welcome. And let me give you a rundown of what we've done thus far. Plaintiff is arguing first. They're in the midst of their argument. They've argued to the court significance of the case regards their client, and that negligent credentialing and agency are still issues to be explored in the case. Agency requires the court to, at some point, or the jury rather, to consider the control that, in this case, Randstad defendants may or may not have had with regards to Dr. Smith. There's limited discovery prior to the August 10 order. After August 10, they've received 94 pages of material, of which there are summaries therein that plaintiffs are requesting a specific culled down set of emails and other documents, and they're therefore, in the plaintiff's view, it is not overly burdensome. I think I've summarized the argument thus far. Take it away, Ms. Clark.
Yes, thank you. Your Honour, and then going back to the 94-page document, there was representations from Defence Counsel that amounted to all of the communications, emails, as kind of a verbatim summary, which I've already represented to the court was not the case. We also know that because you will recall at the last hearing there was an issue regarding a statement that was sent by Dr. Smith to Randstad, and the court ordered that document be produced, or if it couldn't be produced, that a declaration be prepared by somebody with authority in Randstad. Well, that has been prepared, and there was, I believe it was a Wendy Catino, who's general counsel for Randstad. But I think what is significant about the exhibit to her declaration, which was only related to a search for a certain limited date, I believe December 27th, 2013, December 16th, 2013, and January 6th, 2014.
And this is Exhibit V to your Ms. Poole's declaration, is that right?
I believe so. It's V and W, I believe.
Right. V and W is the blow-up of the screenshots.
Yeah.
Okay.
And what the screenshots is, it seems to be like the first line of an email. And I think what is significant there, Your Honour, is the fact that there are several emails that are contained in the exhibit to that declaration that are not included in the 94-page summary document. So what that tells us is that this 94-page summary document is not is not complete. And there are certain, within the emails that were referenced in that exhibit to Wendy Catino's declaration, there are certain emails that appear to could be relevant to the case that directly relating to Kelly Swalling and issues that would occur that occurred, and we can't figure out what was said in the email because we've only got the first line. But there are things like February 11th, 2014. There appears to be an email from Dr. Smith to Dr. Berg. It starts off by saying, "Thanks, Ryan. This is like Days of Our Lives," or something. Jim literally sounded like someone stole his, and then it cuts off. Jim is we understand that to be Jim Anderson, who is an employee of Urgent Medical, so that appears to relate to something to do with Kelly Swalling or something to do with something that's going on at Urgent Medical. A similar email to 2714.
Give me that's Exhibit
That's
W.
Exhibit W, yeah. To
Page, and if these are the ones referenced or set out in your motion at page 9.
Yeah, I think it's page 7. I think these are on page 7, Your Honor.
7.
Yeah.
Okay.
I think there's like
Yes, I see.
4 or 5 of them.
Okay.
And so these emails relate at least to something that's going on with Dr. Smith at Urgent Medical, may or may not relate to Kelly Swalling specifically, but reference employees of Urgent Medical and reactions that they are having to a situation that's going on. None of these, or the majority of these emails, are not contained in this 94-page summary. So the second thing that we're asking for in this motion, and bearing in mind that these searches and these emails have only come up for a very limited time frame, we're asking for copies of all of the emails that are referenced in the declaration in Exhibit W, which was the exhibit to Wendy Catino's declaration.
Okay.
Because many of them appear to be related. They're all related to the time frame at issue in this case. So that's the second thing that we're asking for. And then thirdly, it's our belief and assumption that given that Randstad appears to keep this running document, that's the 94-page document that was produced, which is a summary of communications with Dr. Smith from January 2013 through 2018. Most of that time period postdates the carrot issue. The carrot issue in this case was December of 2013. But in terms of issues relating to negligent credentialing of Dr. Smith and relating to agency issues and how much Randstad, as a matter of cause, is exercising control over Dr. Smith's actions, it's our position that information that predates 2013 is potentially relevant to those claims. And so what we're asking is that a document similar to the one that has been produced be produced for the time period 2008 through the end of 2012. That is the time period that we don't have when we know that Dr. Smith was working with Randstad. And again, it's potentially relevant to negligent credentialing and agency issues. Just by way of example, and this is referenced on page 8 of our briefing, contained within this 94-page document, there is a communication on December 19th, 2013, which is a communication between Ryan Berg at Randstad and Dr. Smith, and it says, she's weeding out the drug patients. Before she fills their pain medication, she's making them do a drug screen, and so far they've all failed. Much more complicated IM cases compared to UC. I told her, this is Brian Berg, I told her not to sign anything she isn't comfortable with. Initially, she handed that last home health patient off to her PA at the clinic. I told her that I would provide feedback to her on that. Lastly, please call me when you are free. At this point, I do not want you signing off on any home health patients you have not personally seen. Also, are you supervising the PA that is working at the clinic? I want to ensure that you are not in a supervisory role for any NP PA at the clinic. Thanks, Ryan. When we're talking about issues relating to control over medical care and actions that Dr. Smith has taken in places that she is placed as a locum, this information is clearly relevant to that issue. So, Your Honour, the third thing we're asking for is for this similar summary document to be produced, and if within that document from 2008 to 2012 we identify specific emails or communications that we believe are relevant to the issues in this case, that they be disclosed thereafter. But rather than having the defendant, Randstad defendants, go to the trouble of having to find all of the documents, we will look at a summary and identify those documents that we feel are relevant.
That 2008 to 2013 set, is that requested in your initial discovery request? I believe it's fairly broad. I looked back at it, any and all.
They're extremely broad. I believe that request for production 1 asks for all documents, communications relating to the relationship between Dr. Smith and Randstad. I think request for production 4 relating to relationship between Dr. Smith and urgent medical.
And so I'm sorry to interrupt. And so my order was narrower, but as a result of the 94 pages of what you've seen, that is now, you're asking me to essentially re-expand that scope based on these theories of agency and negligent credentialing.
I think that's probably a fair summary, Your Honour, because obviously we didn't know that all of these documents, we do have very broad discovery requests that would cover, not only the summary document, would cover every single document that's referenced in this summary document. So there are these documents that exist that have never been provided, even though we've been asking for, relevant documents since the outset of this case. So this isn't a new request. I think the way that I would frame it is, we've been asking for this kind of documentation for years, a year or more, and we've realised that in response to the last motion to compel the production of this document has made us realise how many communications that there are. So it's it's partly a request to enforce the prior court order, but it's also a request to compel discovery of documents that have never been produced and have been asked for at the outset of the litigation. The defence position, I believe, is that this is not relevant, this is a distraction, this is a fishing expedition, this is a medical malpractice case, and we're pursuing claims against discovery against Randstad. But Randstad, if there's a principle of Dr. Smith, which is what we are alleging, this is highly relevant. Randstad is a multi-billion-dollar corporation, and while we understand that it may not be convenient for them to go back and look look for some of these documents, we've done our very best to limit the scope. We haven't asked for every single document, and this is a substantial value case. My client has very limited means. Randstad has substantial resources, and the discovery rules are sufficiently broad, and that we believe that this information is relevant and should be disclosed. And so we took the liberty, Your Honour, of preparing a draft order, which really, I think, delineates what we're asking for. The similar summary statement from 2008 to 2012, specific communications that are referenced in the 94-page summary document, and then the emails that were referenced in the exhibit to Catino's declaration. And two other things, I think, just to kind of clean matters up, we've also asked for, and I believe the defence have agreed to provide, timesheets for Dr. Smith. And also, we've never received insurance information pertaining to what insurance Randstad has for its own acts of negligence. We've had insurance information through Randstad for Dr. Smith, and I believe that there's an agreement that be produced. I would ask that those issues be included in the court order, really just as a precaution, so that we don't end up back before the court yet again on another motion to compel. So, Your Honour, I'm happy to expand on any issue or answer any questions the court may have.
I do have a couple of questions, and I don't know that we're necessarily going to get to answers today, but in particular, I am aware that principal agency liability depends in part on the ability of a party claiming such to establish that the principal is directing the work of, that's one of the elements of the control analysis. I think it's 3 prongs. It's been a while since I looked at that, but that one of those prongs is whether they direct the work of the agent. And I'd be curious here whether they have to direct administrative work or medical work, and I don't know if the same, if the liability arises from medical negligence, do you get to sort of attach entity or principal liability based on control over other aspects of that agent's conduct? So I'm just curious about that. I don't know the answer. It may be too early to know an answer at this point. And I did have another point, and I lost it. So I'll turn it over. It'll come up again, and I'll interrupt somebody.
And if I can just address the one issue on
Go
the,
ahead.
on the agency issue, and I don't know myself the answer
Right.
specifically to that question, but what I will say is that, you know, in many respects it doesn't matter for the purpose of this case, because we have clear evidence that there is direction of medical care by Randstad over Dr. Smith, not only kind of generally in relation to, you know, other issues, but there, you will recall from the last motion, and I think we submitted with our last motion some extracts from Dr. Smith's deposition. She called Ryan Berg on the 27th, on the day that she saw Kelly Swalling, referring to it being a risky situation. Now, the defence is saying, well, that never happened, that's a fiction. That's what the witness said under oath in her deposition. So, at a minimum, there's a question of fact to go to the jury on those issues. And the element of control, I think, is only one of the numerous agency factors that were discussed in our previous, briefing. Dr. Smith also calls herself an employee. They paid her malpractice insurance. They paid salary. There's a number of factors, but the control issue, there is administrative control, but we also contend that there's a question of fact as to whether they're exercising control of the manner that she conducts her medical care of patient, and it's very clear from the information contained within that 94-page document that they're doing that. They're giving us specific information about what she can and shouldn't do, you know, with patients and supervising PAs, etc.
Thank you.
Thank you.
Counsel, Ms. Botso?
Yes, thank you, Your Honor. What I want to just note sort of at the outset is the document that was produced, the 94-page document, is in no way, and I'm sorry, my voice is starting to leave me, so.
I had the cold already. I'm already
I
recovered.
feel fine, but
Sure.
it's wavering a little bit.
That's good.
But the 94-page document that was produced is not a summary. It's not a summary that was generated by Randstad in response to this request for production. This is taken from Randstad's electronic system of the personnel file. So this is not something that was created recently. This is something that was pulled from their system, and these entries were entered in real time at the time that they are referenced here. With respect to the personnel file, of course the personnel file is not going to contain a copy of every single email, whether or not it is, if you have a number of communications on a certain issue going back and forth on a contract, for example, as you may have seen in there, those emails would not be copied over and over and over again. Only pertinent emails are copied and included in here. So I want to just note that at the outset. This personnel file has nothing to do with credentialing. Credentialing is an entirely separate issue. Credentialing has to deal with confirming the qualifications and licensing of a healthcare provider before they provide care or step foot into a healthcare facility and treat patients. So there's this kind of conflating of the two that I think is could potentially get in the way of the analysis here.
They have reviews as well, right? And they're every 3 years, 5 years, something like that.
Correct. Recredentialing.
Recredentialing.
Yes, where you will get updated licenses, an updated CV, for example. And the way that it works at Randstad, this staffing agency, is with independent contractor providers who want to find locums tenens positions through the agency. Those jobs will be put out to the providers, and if they express interest and they consent, then their resume will be forwarded to a medical provider who's looking for an employee or for someone to come do locums tenens work. At that point, in this case, we'll just say urgent medical. So urgent medical would have gotten Dr. Smith's CV and would have decided whether or not they wanted to interview her. And this is all reflected in the 94-page notes. And so after that happened, they decided they wanted to interview her. She went in for an interview. Then they decided they wanted to proceed with her for the locums tenens position. At that point, the entire credentialing packet is sent to UNC for them to decide and ensure and confirm that she is who she says she is. She has the qualifications that are listed on her resume, all of those sorts of things, and then to subsequently provide medical care for the dates that they want to. So I just want to give that sort of big picture as to how this all works. Randstad gathers all those documents for the healthcare providers and for the entities, and then once they decide they want to move forward with a potential independent contractor, then they pass those along to the entity, and then they take it from there. If they need any additional credentialing after that point for insurance, that's all on the entity. It's not on Randstad. So with respect to the agency theory, I just want to briefly touch on that. Many of the, maybe what I did, and maybe the court can tell me if you think that this is helpful. We received a letter from plaintiff's counsel that was attached to their motion that outlined all of the documents that they felt were reasonable. What I did is I went through and just pulled those pages and highlighted them and extrapolated them, and I brought a couple copies. Would it be helpful to go through that? Because there's a few things that I want to point out in here.
If it's your argument, you want me to look at it, I have no problem with that. I recognize that table-style document as being more fully set out in plaintiff's, Counsel Poole's declaration. I believe it's also in Johnson's declaration.
Correct. It's in Exhibits 2 and 3.
Okay.
Twice.
So that's fine, so long as plaintiff has the benefit of looking at what I'm looking at. Sure.
Absolutely. All it is just pulling the. May I approach?
Sure, please.
Thank you. All it is just pulling out from the documents that were submitted and highlighting the ones that are outlined in their letter and consequently in their proposed order here.
Okay.
So, if we look at, for example, if you turn to there's a Bates number, Randstad Notes 5. So, just to kind of give the court an understanding of this document,
Okay.
the plaintiffs have requested any and all documents relating to any of the entries that are highlighted therein. So, with respect to emails, those emails are copied and pasted directly into the system at Randstad, which it used to be an old system, and then it was some years ago after this, it was transferred into this new system called eRecruit. And so they're copied and pasted verbatim in there. Where it says info screening call, that's just a note action, which all it means is it's a notation of a call. And so that is something that someone typed directly into the computer system. There would not be any additional documentation or notes beyond that. That's just because this is a running, living, breathing system. So they're typed in real time as it occurs. You can see the timestamp, etc. Sometimes, unfortunately, because some of the note actions are, don't correspond with the note, where one might say info screening call, but it might reference an email. And it's my understanding that when the system was transferred over to eRecruit, some of them were just automatically categorized from the old system. So that would be the reason for the discrepancy there. So, but if we're looking at page 5, for example, at the first one that they want from June 3rd, 2013, all this is a enclosure email asking, submitting updated credentialing documents to Dr. Smith, asking her to confirm them. What we have to remember is that the plaintiffs also have the complete credentialing file. So any documents that Dr. Smith would have sent back to Randstad and filled out are contained within the credentialing file. And these all correspond. I mean, right around June of 2013, the credentialing file, which was produced in response, all of those documents are contained therein. Let's see, the 2013 credentialing, I just got to get the page number where it starts, is page 84 of Exhibit 4 to Mr. Johnson's declaration. So there's the whole re-credentialing packet there with all of the June 2013 re-credentialing documents.
You said page 84, that give me a moment. I have it up here. This is why I need my readers.
And I apologize, Your Honor, that you did not get a hard copy.
Oh, that's fine, that's fine. I just don't like a huge screen on my bench here because I can't see the jury, so I have a tiny screen.
What page did you say you were on?
It is, so it's, in Exhibit 4, Mr. Johnson's declaration. If you get through it, there are Bates numbers down at the bottom that says Smith credentialing file.
And the PDF page for, if you're ever,
The PDF
Pressing.
page might be a little higher.
the PDF page, yeah, is different. And so Exhibit 4 on the PDF on our Liberty system begins at page 220. So let me get there. And while I'm getting there, I know we're still discussing that June 3rd entry. But the question I had that I now remember, so I'm going to interrupt the argument. I know this is horrible on the record because it's hard for an appellate court to track sometimes, but Ms. Clark, I may have asked you this last time. Are these agency claims pled in the complaint? I didn't look at it this afternoon. And statute of limitations, do you have time still? So if we're going towards these agency or negligent credentialing claims, you're not precluded under statute of limitations. They've been pled already. Will you be seeking leave to amend if you discover more? How's that dealt
I
with?
don't believe this is in the notice pleading state, so I think we've named them in the defence, which we've alleged that
Okay.
they are the parties, and so they're currently
feel it's
covered
sufficient?
under the statute of limitations. I mean, there is no requirement that you have to put specific, allegations in a complaint in Washington. So yes, and we've named all of the potential Randstad defendants.
That's right.
So, yeah.
It's an extensive caption, I've
Yeah,
noted.
yeah.
Okay, thank you. So continue on. I'm at Exhibit 4.
As you'll see, the re-credentialing packet there, if you go through it, that begins in June of 2013. It has all of the updated documentation from the initial credentialing, which the plaintiffs have going back to 2009. So any new updates, you can see on the first page there, it references where there are no changes. For example, there wouldn't be any changes in her copy of her driver's license, etc.
I see a cover letter, I see a privilege log, and then I see a verification checklist, and then her CV. So direct me to the Bates number would be fine. Smith credentialing file
84.
84. Goodness. So I'm not a fan of the electronic system we have. Not that you all care, but the clerk's listening. Okay, so I'm on 84.
Right, so this is where the re-credentialing for June of 2013 begins, and this would have been applicable for the relevant time period, which is December of 2013. And then when Dr. Smith took a job in January, a full-time position in January of 2000, or a more permanent position, I should say, in January of 2014 with Randstad, then there was some more credentialing done at that point.
And so these items, they're somewhere in this credentialing file. Is that email referenced in plaintiff's motion that's also set out in at 005 of this item you've said you've handed to me?
Not the email directly, no, but any of the documents responsive that would have dealt with re-credentialing, because the email just says, "Hi, Dr. Smith, please see the attached re-credentialing packet. Since your file will expire in July of 2013, I've completed as much information. Please complete the sections and fax back to me." So the documents were faxed back, and they're here in the file, but it looks like what the plaintiffs want us to do is now go and get the actual email with the documents to show what we already know, which is the completed documents are in the file. So there's a lot of duplication going on here, and this, runs throughout the various requests that have been highlighted here by the plaintiff. With respect to any of the December 2013, thank you, Your Honor, entries that they've requested, those have nothing to do with the care provided in this case, let alone supervision. One of them has to do with, if we go back to the page that we were on, which is Randstad Notes 5 of the packet that I handed you at the bottom there. Hi, Amy, we have a provider available for coverage, and they talk about her schedule. And to go back to the court's question about administrative functions in agency claims versus whether or not they're directing the medical care of patients, yes, the court is correct. That analysis is very pertinent in terms of whether or not there's agency. When Randstad filed a motion for summary judgment on the agency issue, we fully briefed this, and Washington courts have been clear that administrative things like scheduling, payroll, those sorts of things do not give rise to an agency claim. It's whether or not you are directing the manner in which they're performing their work. In this case, it would be how are they treating particular patients and the care that they're providing to the particular patients. So this is an email for an entirely unrelated entity about scheduling, and so I don't see the relevance here when the plaintiff has identified virtually. I mean, the number of entries is, I didn't go through and count, but it's a lot. So to have Randstad go back and get these documents when they have nothing to do with proving an agency claim, let alone credentialing, I don't see the relevance, and it's overly broad, it's unduly burdensome, and they haven't shown that it's reasonably calculated to lead to the discovery of admissible evidence when they have the actual text of the email in this document, which is created in real time. It's not a summary that was created recently, as I stated earlier. With respect to a number of the other entries, even after 2000 and December of 2013, it's a lot of the same. The emails that are referenced, or that were referenced in Wendy Catino's declaration, those all have to do with contract negotiations. And if you look at the notes document, at the eRecruit notes document, they all have entries at the same time of those emails talking about contract negotiation, about Dr. Smith's job that she was going to take after the care at issue here at Urgent Medical Center. That's what those are about. There isn't any smoking gun here. There isn't something that Randstad is trying to hide. But all of this summary, if you put those two together, you can see it's all related to contract negotiations. So her contract negotiations with Urgent Healthcare, Urgent Medical Center, after the care at issue here, has nothing to do with credentialing or agency. And that's what the bulk of these entries relate to. The other ones have to do with a number of disputes or grievances that Dr. Smith may have had with other entities, and at times with Urgent Medical Center, but nothing to do with medical care, nothing to do with treatment of Kelly swallowing, and nothing that was included in the scope of the court's order on August 10th. So,
are they required to take your client's word for it that they have nothing to, that these disputes have nothing to do with her competency to practice medicine?
Your Honor, I think that a lot of this could be very easily resolved with the 30B6 deposition that the plaintiff requested back in August and still has not noted. I've requested numerous times in writing that we've identified Wendy Catino, we've identified that they outline the various topics that they wish to be covered, and all of this could be resolved in that deposition, but there's a delay saying, well, no, we need every single piece of paper before we're going to depose. And that just doesn't make sense. It doesn't make sense for the burden that it would put on Randstad to do that, and especially in light of the fact that this is not, it's just not related to the claims of agency or credentialing. And Ms. Catino can testify to that in her deposition. So I think that a lot of this could really be alleviated if we just move forward with discovery as we've been trying to do all along.
And so specifically what plaintiff is referencing in their motion is at page 8, credentialing, supervision, other agency issues. So just putting that out there, would are they entitled under CR 26 and the scope of discovery allowed therein to make their own determination as to whether those conflicts or difficulties that Dr. Smith had with previous placements or wherever else in her career, that those would be material or relevant, probative to whether she's competent to practice medicine?
I think the answer to that is no, Your Honor. And as I stated originally, we're conflating credentialing and employment issues. It's just as if I were to apply to work at a law firm. They want to make sure I'm licensed. They want to make sure that I passed the bar. They want to make sure I haven't been disciplined. But they're not going to go and ask my employers for every single email about me before they hire me to make sure, or if I ever had any unhappy clients before I start working providing legal services. It's the same. They're separate here. There's this conflating the personnel file with credentialing, which is this person a medical doctor? Is this person licensed? Have they been disciplined? Has there been any sort of action taken against them before? Have there been any malpractice settlements? The answer to that for Dr. Smith is unequivocally no, she's never been sued before. Yes, she was licensed. All of that information was provided to Urgent Medical Center. And so, no, I don't think that they're entitled to go into that for credentialing issues. I think that those are absolutely unrelated. They're irrelevant. And I mean, it's essentially character evidence of trying to say, well, she has all these employment issues, employment disputes, therefore she must not be good at treating patients. The two just don't connect. There is not a plausible nexus between the two.
Anything further?
I think that's it, Your Honor.
Okay, thank you very much for your argument. Counsel?
Yeah. Your Honour, they've clearly gone and looked at these emails, because if they're representing that there's nothing in these emails, that they don't believe there's anything that's relevant to the issues in this case, then those documents must be very easily accessible. I'm assuming that somebody from Randstad or somebody from Defence Counsel's firm has looked at those, be able to make that representation. Therefore, there shouldn't be any issue about producing them to my firm. I don't think they get to decide what's relevant and not relevant. I mean, clearly they have their own interest, and we have ours. Ultimately, as to whether something is relevant and goes in front of a jury would be a question for Your Honour at the time of trial. But the discovery rules are very broad, and I believe that they are, if there's anything in there that could be potentially relevant, then they are discoverable, and the rules clearly state that. I don't believe it will be overly burdensome for them to produce them, because they've obviously looked at them already. And as far as addressing, well, this could all be addressed in a 30B6 deposition. Well, that's not correct, because part of what we're going to be doing in a 30B6 is saying, okay, well, what was in this email dated, December 14th of 2014? Well, they're going to have it in front of them, unless whoever is being deposed can memorize every email. And the reason we've delayed in scheduling the 30B6 is we want to have the documents to be able to ask questions about those documents in the 30B6 deposition. I don't believe this is an overly burdensome request. The pre-2013 summary document, it sounds like that is very readily available and could be produced. The emails that we're asking for in the declaration of Catino presumably have already been reviewed by her, so that they should be available, as should any of these other emails that are contained within the 94-page document. What is contained within a file they choose to call a credentialing file? Negligent credentialing claims may go beyond that. I mean, just because I call a file, Mr. Smith's file, and put some relation to Mr. Smith in there, there may well be other relevant information that's not contained within the doctor's credentialing file that may be relevant to negligent credentialing claims. Just because they put it in a file and call it a credentialing file doesn't mean that is all and complete and the only evidence that's related. So, Your Honour, we have narrowed the issues. We could have asked for a whole lot more. we've tried to limit those that we feel are relevant to the claims that we're pursuing in this very substantial value case, and I would ask that the court grant our motion.
Thank you for your briefing and arguments. You on both sides did a great job with it, so I appreciate that very much. I feel I'm up to speed on the issues presented to me, so that's as a result of your briefing. Again, thank you. Rule 26 governs discovery breadth in general. At B1, parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to a claim or defense of the party seeking discovery, or to the claim or defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of any discoverable matter. It is now ground for objection that the information sought will be inadmissible at the trial if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. The court is aware here that I may limit discovery under certain circumstances. I don't feel that these requests called down and put forth in plaintiff's proposed order are overly burdensome. I do think they're reasonably calculated to lead to discoverable evidence, in particular evidence related to these claims regarding negligent credentialing, negligent supervision, and other agency issues. Because it's not unduly burdensome, I think they should be produced. I'm ruling that they be produced. We have yet to get to these more detailed issues regarding agency, and I don't doubt that that's on the horizon here, but I don't see, again, a reason to limit the discovery aside from, plaintiffs have already made a good faith effort to do so. And so their proposed order is consistent with my ruling, and I will adopt that proposed order.
If I may, Your Honor?
Yes.
One of the things we didn't address were the privileges that were
Yes.
Yeah, there were a number of entries that we redacted, and we included a privilege log, and I believe one of the items in the proposed order says that, or asks that be produced in unredacted form. I would ask then that the court perform an in-camera review of those redactions, as there's personal health information, various other prior to that, and I do have a copy of it here today in unredacted form to provide to the court.
And I've finished all my other in-camera reviews, so it shouldn't take very long. Do you have any position on that?
No objection.
Okay, so ordered. If you'd add that in, Ms. Clark.
I guess I just need to know the specific one that it relates to.
I believe it relates to
The notes,
9314.
What number, do you know what number it is on the proposed order?
It is 17,
The 9, 13, 14?
18. 17 and 18, I believe. And then, Your Honor, there were some other redactions earlier in the document that the plaintiff did not object to. I've included the entire unredacted, but just to apprise the court of that. Those are the 17 and 18 are the only redactions that are at issue.
and so you'll conform your order consistent with my order that I'm doing an in-camera review?
Yeah, I guess what I would ask is that they be discoverable, subject to any redactions that the court feels are appropriate. I guess we just need to add that wording in on 17 and 18.
Noted, and so ordered. I will produce my own log of what I think is privileged and not. I will say, I've purposely taken an incremental approach to the discovery in this case. And I did narrow it down on the first order of 8/10/2018. And with the production of those documents, there do appear to be some, I think they were termed red flags by plaintiff. I share that. I think there are some additional documents that should be disclosed, and that's why I'm doing it the way I am. An incremental approach. There appears to be facts in those initially discovered documents that lead to an additional viewing of a broader set. And so that's my purpose here. That's the reasoning. Do you all want an opportunity to review the order?
If I may raise one more issue, Your Honor.
Sure.
Item G in the order, proposed order says if defendant is unable to produce any of the documents ordered for production, defendant is ordered to prepare and provide plaintiff with a detailed sworn statement by a representative with authority on behalf of Randstad, setting out specific details of all searches made for said documents, dates, what was searched, the full identifying information, including names, job description, and of all persons involved. Your Honor, that is, with respect to what I explained earlier, for example, there are no documents associated with just the notes that are already in there. So is the court then going to order that we produce a sworn statement stating that we searched for those documents when we note that they don't exist, or can we tailor that somehow?
My purpose is, and I've had this happen in the second week of trial on a case, a civil case here, where things will come about mid-trial or right before trial. My purpose is to hem in the parties, and it goes both ways, and is so we don't have those surprises. And so I do this with an eye towards trial. And so I want Randstad to be held to their answers. It may be there's nothing found. It may be there's no smoking guns back there. We're in a different position, I suppose, if that happens. And I'm not showing my cards necessarily. I don't know. And so, my intent is to for answers to be answers, and so I do that routinely on other cases. So I do think there should be a binding of the responding party to their answers. That's my intent.
And then doing this before November 1st is, I don't think, practical. So I would ask for a month.
When's trial? October next year?
June.
But we do have a deposition, I think, of Ryan Berg that was originally set, and then it was reset, so we could get this hearing. So I think that's set for November
30th.
November 30th. So I guess we need to be able to have these documents in sufficient time to prepare for that deposition. So I would say maybe November 7th, 10th, something around then. We just need to, if there's a substantial number of documents, we need to be able to prepare to take this deposition.
We potentially do November 15th. That's more than 2 weeks before the deposition.
Well, that gives them a month to get them to us, and we only have then 2 weeks to look over everything. And it's Thanksgiving in the meantime, so.
You said the 3rd, the 28th of November is the deposition?
30th.
The 30th? That's 43 days away. Splitting the difference is about 21 days. So 21 days from today is November 8th. 10th is a Saturday. I'll go to the 9th.
Okay.
November 9. It's about 3 weeks. That's it. So take a moment, look at the order. Let me know if you have an agreed form of order. If not, I can take the bench again and address any concerns.
And I guess all that I've done, Your Honor, is I've added in on 17 and 18 we've listed out what's to be produced, and I've just put the court to review redacted entries prior to disclosure. Is that
That's fine.
sufficient?
That's fine.
And then I've just changed the date of the, to the 9th, so council agrees, and I think that was the only thing that we should take out.
Okay. So I'll step off the bench. I think we'll leave Ms. Fronefel on the line.
Till tomorrow morning.
Are you still with us?
I am still
Okay.
here, Your Honor. Once you leave the bench, I think I'll drop off.
Okay, very good. We may be back on for more argument, but,
I
never
think
mind.
we're set.
We're set. We have an agreed form of order, so I'll entertain that at this point.
I need to provide the redacted stuff to the judge now.
Yes.
Do you want that back?
I think we get what we don't have to. Those are the unredacted notes.
And it'll just, we can just come down to the office and get a copy of the order, later or this.
Okay. Okay.
Because they don't have a version of the redaction of it, so I'll just come back.
You can take it down and file it.
Okay.
You can take it down. I'll give you permission. I do that all
And
the
then we
time.
just have to make a copy of it.
Sure. Here's my order. Okay, thank you.
Thank you.
We're off the record on
Thank
this
you.
case. Thank you very much, Ms.
Thank you.
Fronefel.
Thank you. Goodbye.
Thanks, everyone.
So I'll go and